Getting a green card through family is one of the most common ways of becoming a lawful permanent resident. In this video, we'll go through the general process of getting a green card through family, who qualifies, and the exact forms that you will need to submit. How does the process work? It starts with someone who is already a US citizen or lawful permanent resident filing a Form I-130 on behalf of the person hoping to immigrate. The person who files this form is known as the petitioner. The person for whom the petition was filed is known as the beneficiary. From there, the beneficiary needs to fill out a separate application. The exact process will depend on several things, including whether the beneficiary is already in the country. You may be wondering, what kind of family qualifies? There are two categories of family-based green cards. The first are for immediate relatives of US citizens. If the petitioner is a citizen, his or her spouse, unmarried children under 21, and if the petitioner is over 21, the petitioner's parents qualify as immediate relatives. The other category is known as family-based preference. If the petitioner is a US citizen, this includes children over 21, married children of any age, and siblings. If the petitioner is a lawful permanent resident but not a citizen, it includes spouses and unmarried children. What about the beneficiary's family? If you're a beneficiary who meets one of these qualifications, you can bring along additional people that the petitioner can include on the same application. These people are known as derivative beneficiaries. If the petitioner filing on your behalf is a citizen, then the beneficiary's spouse and unmarried children under 21 can be counted as derivative beneficiaries. If the petitioner is a lawful permanent resident, then only the beneficiary's unmarried children under 21 qualify. What about a fiancé? There's no special category for fiancés. Instead, there are two possibilities. The first is that the petitioner and the beneficiary could get married. Then begin the application process. Hooray for a wedding! If the fiancé is out of the country, the other option is to file a separate application that allows the spouse-to-be to come to the United States for the purpose of getting married. If you're a petitioner and it looks like you have a relative who qualifies, how do you fill out a Form I-130? Much of it will consist of biographical information about you and the person on whose behalf you are applying. You'll need to provide copies of identity documents like a passport. One thing to keep in mind about applying on behalf of a spouse or a fiancé or for an existing marriage, US citizenship and immigration services will consider at some point whether the spousal relationship is legitimate or a sham devised for the purpose of obtaining a green card. You should be prepared to provide documentation that your relationship is real, such as evidence of you and your spouse living together for an extended period. What happens after you file a Form I-130? The next steps will be carried out by the beneficiary. What to do and when to do it depends on two things: whether the beneficiary is an immediate relative and whether the beneficiary is already in the country. If you're a beneficiary but you are not yet in the United States, you will go through consular processing. This involves waiting for the I-130 filed on your behalf to be approved. Once it is, you'll be notified and you will be set up with an appointment for an interview at the US Embassy or consulate in the country where you are living. The office will decide whether to grant you a visa that will let you come to the United States, where you will receive your green card. If you are a beneficiary and are already in the United States, you will go through adjustment of status. This requires filing a Form I-485. Unlike Form I-30, which is done by the petitioner, the beneficiary fills out the Form I-485. Once approved, you will receive your green card. Under either process, a beneficiary cannot continue until a visa is available. If you are an immediate relative of a US citizen, then a visa is immediately available. This means that a visa will be ready for you as soon as the Form I-130 filed on your behalf is approved. In fact, in some cases, it will be ready even quicker. If you're pursuing an adjustment of status and are an immediate relative of a US citizen, then you can file at the same time as the Form I-130 is filed, a process known as concurrent filing. Concurrent filing is not available for those applying through consular processing. For all others, you may have to wait a while to advance in the process. Federal law limits the number of family preference visas that can be issued in a given year, and that allotment is further broken down by the type of relationship the beneficiary has with the petitioner and where the beneficiary is coming from. If there are more applicants than visas in a particular year, a line begins to form. The U.S. Department of State publishes a visa bulletin every month that indicates when a certain type of application is current and eligible to advance in the process. For some, the wait for a visa can last years. If you want to come to the United States on a temporary basis and apply from here, it's possible that you could run out of time on your temporary visa before you're eligible to move on the process. Remaining on an expired visa can have consequences for future immigration applications. On the other hand, if you return to your country of origin, you may have to start the process all over again. Those trying to decide between consular processing and adjustment of status should consider consulting an immigration attorney. We're eForms, the biggest online database of legal documents. Click the link and get started on yours today.